I will start my presentation by explaining to you why there was a need to legislate in the area of service of justice. You may probably know that each regulation, each EU instrument is subject to revision by the Commission at a certain period of time. And during this revision, the Commission actually evaluates how does the concrete instrument functions, whether there's some deficiency, whether something should be improved, and what should be done with the instrument. And while the service of document was actually evaluated, it was actually discovered that there is a need to start exploiting better the advantages of the modern technology. You know that all of us, a long time ago, we entered into the digital era, and many of us, for example, do not go to their banks nowadays because we all use our online banking system. And it was actually thought that it will be good probably to use this modern technology in the area of service of documents and, well, taking of evidence. They were all together. That's why I very often, you know, for me, they're like twins nowadays because the negotiations went both for the service of documents and taking of evidence. But why the Commission decided to make this proposal? Because it wanted to avoid delays and costs for those persons who are involved in cross-border judicial proceedings, but they also wanted to relieve a little bit the administrative burden from the court staff or the judges themselves sometimes, because I, for example, as a judge, very often filled in the request myself. I didn't have help for this. And the evaluation also showed that the traditional channel for communication, which is basically the post, was underperforming, and that's why it was thought that probably a use of a new technology would be much better. And also that the service by post was not very reliable. I don't know how it is in your practice, but in my case, I very often had occasions where I either don't have anything returned, or I don't know what happens, or something is lost. So the Commission thought that probably introducing a new method of communication would, in a way, relieve or make the service much more efficient. Then the negotiations started in October 2018, and last November, on the 25th November, the regulation was adopted and it was published in the official journal on the 2nd of December 2020. What does this mean? It meant that 20 days after the publishing in the official journal, the regulation entered into force. So at the moment it is enforced, but it will be only applicable as of 2nd July 2022. You will note in the regulation itself that there are two dates of application. The first one is the one that I mentioned, 2nd July 2022, and this will be this part of the regulation which does not deal with electronic service. So none of the features of the digitalization will actually be applicable as 2022. Those features or the digital part of the regulation will start applying, as the regulation says, 3 years after entry into force of the implementing act, which will establish the decentralized IT system for the electronic transmission. A bit later on, we will see what exactly this decentralized IT system means. It's good just to remember those two different dates of application, and we will start actually applying or exchanging electronically 3 years after the entry into force of the implementing act, and the implementing act itself will be adopted by 23rd of March 2022. Somewhere at the final provisions of the regulation, there is this possibility for the member states to inform the Commission if they're in a position to use the electronic exchange system a bit earlier, but this will be on a voluntary basis and there will be no obligation for the member states to exchange electronically before this 3 year expire, 3 years after the implementing act expire. So what is the scope of the application? It didn't change a lot. It is as you know it. It applies to cross-border service of judicial and extrajudicial documents in civil and commercial matter. What the regulation does, however, is to clarify a little bit what exactly is a cross-border service and to make sure that a cross-border situation will not be transformed into domestic situation as very often happens in the practice. So the recital 5 of the regulation clarifies that a cross-border service is a service from one member state to another member state. And this usually applies in the situations where the addressee has no address for service in the member states where the proceedings are taking place, but has one or more addresses for service in another member state. And this is actually the cross-border element. If this is the situation and you find yourself adjudicating a case where one of the parties has an address in another member state, according to the regulation, you cannot regard this case as a domestic case and to use like fictitious methods, methods of service, like for example, to post a notification in the court board, or just to enclose the documents and to consider them served. The regulation for the first time defines what is an extrajudicial document, and here on this slide you will see I refer to a case of the Court of Justice. This is the TECOM case, and the whole definition of the extrajudicial document actually was inspired by this case. And what does it say? The regulation, it is in the recital, it's not in the articles themselves, but it says that an extrajudicial document is such a document which was drawn up or was certified by a public authority or an official, or any other document which formal transmission and service on a party residing in another member state is necessary for the purposes of exercising, proving, or safeguarding a right, a claim in a civil or commercial law, which means that this might be even a statement for certified by a notary or some other statement of the party. This type of documents will be considered as extrajudicial. What will not be considered an extrajudicial documents, those would be administrative documents or documents issued by administrative authority, because as we said, we are here in the domain of the civil and commercial law. Then, of course, the exceptions from the scope of application, there is actually no difference here. The regulation remained unchanged in this part. So the regulation will not apply for the service on the party's authorized representative. However, there is a slight clarification here because the national law of some member states requires some documents to always be served personally on the party. So if this is the case, even if the party has an authorized representative in the member states where the proceedings are taking place, but the party, her or himself, lives abroad, then the service must be effected abroad if the national law foresees such situations. Like, for example, the example was given with the family law case, and if there is a divorce case, and the national law requires a personal service, so even if the party has a representative in the foreign member state, the service has to be done abroad to the party herself or himself. Then, of course, the regulation will not apply to revenues, customs, administrative matters, and the so-called acta iure imperii, where the state actually exercises powers. And the last instance when the regulation will not apply, this is where the person has no known address. There we'll see one exception of Article 7. We will come now shortly to Article 7. This is the article which requires or which allows the parties to request assistance from another member state in order to be able to find the address of the person to whom the document should be served. So this is the only exception. You may not know the address of the person abroad, but you may request, based on this regulation, assistance to find out where eventually the person resides or lives. Then this is the very, very new feature of the regulation, and this is something which will actually start applying, as I told you, 3 years after the system for electronic exchange is set by an implementing act. And this is the so-called mandatory electronic exchange of a document. So if you want to service a document as a court to another member state, you fill in the form. The form will be all available online in the system which will be created with this implementing act. You fill in the form, and just with the press of a button, the form will be sent to the court which is designated to receive it. So this process of sending the request for service will be simplified very much by using this decentralized IT system. The IT system will be composed of the national IT systems of all 27 member states, and those systems will be interconnected or will be able to talk to each other because of this new interoperable solution which is called ECodex. Then, of course, if there is a problem with the decentralized IT system that for whatever reason doesn't work, then of course you may always use traditional channels of communication. I'm pretty sure you will hear very often nowadays this term ECodex. To me as a lawyer, it sounded a bit like a rocket science in the beginning, but now I have to admit I start to understand more and more what it is about. The ECodex is actually a software which allows interconnection of national IT system. It facilitates the communication because it makes possible in a secure and reliable manner a document from the IT system of one member state to reach the IT system of another member state. It's too technical for me to explain it, but I just put here some information for those of you who understand more than me. But the ECodex is this software product which allows the interconnection of the national IT systems. Then, of course, if we have an electronic exchange, it was very important to include this provision on the legal effects of the electronic documents, because there are many national laws which do not actually allow or which do not admit electronic documents in judicial proceedings. And here we have a special procedure which makes clear that if a document is received electronically, it will not be denied a legal effect or will not be declared inadmissible just because it is in an electronic form, even if the national law foresees this. For the purposes of this regulation for the cross-border case, this document will have to be admitted. Then it's totally another issue, and this is the second paragraph in this slide that you see, is how the court will assess the legal effects or the admissibility of this document for the particular case. What does this mean? Basically, if you receive documents electronically, you will have to consider them as if you have received them on paper. But then whether these documents will be admissible according to your national law to prove the particular fact that it wants to prove, this remains entirely an issue of the national law, and the court, of course, will have the authority to consider how exactly this document or this evidence will be evaluated. You will also see this very interesting recital 16 about the conversion of the documents. And what is this about? Very often nowadays, if we want to convert a document from a paper to electronic form, what we do is that we scan it, or vice versa. If we have electronic document, we just print it. The laws of some member states have these special rules on how this conversion of documents should happen, and the regulation does not interfere with those rules, and those rules continue to apply for each of the member states. But the principle of mutual trust requires that if a document is received from another court or from a court of another member state, that this document is accepted for the purposes of the legal proceedings, no matter how it was converted. And this is the Article 7, which I mentioned. The regulation actually foresees 3 different alternative options for assistance in address inquiries. Each member state is free to choose which of the options will apply, and the choice of the member state should be communicated to the Commission, and then it will be made public via the e-Justice portal. So you see what are the three options. Either the designated authorities, there will be designated authorities to which the transmitting agencies or the courts basically will send requests for determination of the address of the person. What that would mean, like me as a judge, I receive a request based on this regulation to help basically the court of another member state to determine whether and where exactly the addressee lives, if the addressee lives on the territory of my member state. Then the second option is to give possibility of the persons who participate in proceedings to contact directly the competent bodies or agencies and to require information about the address of the addressee. And then the third option will be just to put an information on the e-Justice portal what a person who is interested in finding the whereabouts of the addressee can do according to the law of each of the member states. So those are the three possibilities which each of the member states should decide how to use. Then we have this very, very useful, at least from my perspective, rule about the information on whether the member state performs ex officio search of the address. You know that usually when you send the request for service of documents, very often you received it back and it said it was not served, the person was not found. But then you as a requesting court, you don't know whether the requested court actually tried by its own initiative to find the whereabouts of the defendant. And this is very often the case in many member states. Like for example, in Bulgaria, I know that if I cannot find somebody, then I make an ex officio search in the database and see whether this person has another address. Well, of course, this is not the case in other member states, but that's why we thought that it's very important that we inform the requesting court whether this ex officio search was done, because then the requesting court will be clear what possibilities and what options it has and how to continue with the case. Because if it's clear that the requested member state exhausted all means to find the addressee, then there is no use of addressing the request to them and something else should be done. Then this is this very, very, I would say, tricky article on the right to refuse to accept the document, which actually in substance was not changed. The conditions to refuse to accept a document remain the same. You know that the documents have to be either drafted or translated into a language which the addressee understands, or the language to the member state addressed. And if that is not the case, then the addressee have the right to refuse to accept the document. What is new, however, in this provision is that we have a new rule on the language of the form in which the addressee is informed about the right to refuse. Normally, it is the receiving agency or the receiving court which informs the addressee that he or she has the right to refuse to accept the document. And if we had to be strict, or if we have to be strict today, we have to actually attach this form in all 24 languages, because the current regulation does not have a rule on that. Well, I know that this is not what happens, but probably that was one of the reasons why the legislator decided to address this issue. And now we have a special rule which says that the form which informs the addressee about the right to refuse has to be attached both in the official languages or one of the official languages of the member state of origin and the official language of the member state addressed. And then if in the case file you have some indication that the addressee understands some other language, there are many occasions how you can get such indications, then the receiving agency may attach the form in this other language which the addressee understands. There is also one very interesting paragraph which says that if, for example, a member state made a translation of this form in a non-EU language, then this translation may be provided and may be published on the e-justice portal, which is also probably useful for such member states where you have people from with such an origin or language which is not a new language, and in such case, if the member states decide to translate, for example, in Chinese, then this translation will be provided for further use by the other member states. There is a bit of extension of the deadline in which the right to refuse may be exercised. This may be either at the time of the service or within 2 weeks from the receiving of the document. And this may be done either by sending back the special designated form or by sending a simple written declaration to the receiving agencies about the refusal. Why was this made? Because it was found during the evaluation phase of the regulation that very often the practice used by the parties is very confusing, and accordingly the courts have different approach, and it's not very clear whether something was refusal or not. Because if I just write, I refuse to accept documents, well, obviously I do, but if I don't send the form, then the court consider that this is not a proper refusal and there were no consequences of this refusal. And that's why now the regulation is a bit more flexible, given these opportunities to the addressees to address in the best possible for them way. And if a party refuses to accept document, the service of this document may be remedied by servicing the translation of the document in the language which the party understands, or one of the languages in paragraph 1. Then there is also this, I would say, clarification that it is the court which hears the case to decide whether the refusal was justified or not. And if the court finds that the refusal was not justified, it has to find appropriate way to inform the addressee that the refusal, well, it will be very important in cases the refusal was found not to be justified, because then the party sits relaxed at home and thinks that everything is okay, but all of a sudden it discovers that it's already at the stage of the pronunciation of the judgment, because the court considered that the refusal was not justified. That's why now we have this rule that the addressee should be informed if the court, for whatever reason, found that the refusal was not justified. The Postal Service will continue to apply, of course, in the situations where the electronic service is not possible for some reason. There is a bit of an improvement of the article. The current regulation says each member state may undertake a postal service, and it was interpreted in different ways, whether the postal service can be done only by the state authorities, which represent the member state, or it can be done also by the parties, because you know that in some member states, it is the party's obligation to serve the other party. Now, the regulation makes it clear that the postal service is at the disposal of both the court and the private parties. And in recital 30, we mention the so-called Henderson judgment. This is a judgment on the substitute service. Well, this judgment will continue to apply because nothing has changed in the postal service itself. And if we find ourselves in a situation where the documents were received not by the addressee in person, but by another person, who actually who is one of the persons mentioned in this recital, then we have to consider that the service was validly effected. So there is no need to always service the person in person, unless it is specified so in the national law, as we mentioned a bit before about the family law, for example. But that really depends on the national law. The direct electronic service is also a new feature of this regulation. And for me, the direct electronic service is like the postal service, but in the electronic domain, which means that you as a court may serve the party directly via, well, there are two possibilities basically. One of them is using these qualified electronic registered delivery services, which are regulated by the so-called ECodex regulation. I put here the number for your reference. You can see this is basically this type of service which guarantees who is the sender and who received the document basically. This service is subject to the general consent of the addressee, and this consent is usually given at the time when the person subscribes for the use of this qualified electronic registered delivery service. So once you apply, well, of course, this service is not used only for judicial proceedings, it may be used also in other occasions, but once you subscribe to have this domain there, or this account there, you give your consent to receive documents, including for judicial proceedings, because you know this is more or less like registering your physical address at the municipality. This is something like that. And then the second possibility is servicing directly via an email, but then in these cases you need express consent of the person to the court for the concrete proceedings for which the service via email is requested. And then, of course, if you service via email, there is a requirement to have a confirmation from the addressee that the service was, the documents were received. And in case there is no such confirmation, then you should try to find another way how to service, because this service via email will, of course, not be valid because you don't have any proof for it. Why? When do we do electronic service, direct electronic service to the party? You know that if I'm to be served via an email, it doesn't matter whether I'm in the foreign member state or if I'm in the other part of the world. So just to make clear that this direct electronic service will apply when we have a cross-border situation. The cross-border situation we evaluate based on the fact whether the person has a physical address for service in another member state, which means that, for example, if I'm Slovenian and I live in Slovenia, there is nothing cross-border in this situation, and if the Slovenian law allows for service via email, you can service via email. But if I go and register myself in Belgium, as is my case now, then even if I'm Slovenian, you have to apply this regulation, and then you can service me via email if I requested so during the proceedings. Then, of course, the electronic means for service have to be available under the law of the member states for the domestic service, and particularly for the service via email. There was a compromise. It had to be reached here, and some member states, the member states were basically giving the possibility to set conditions under which they will accept service via email. But those conditions are not so broad because they may only relate to the security of the transmission, and they may be specified only if the national law does not allow for electronic service via email or it has stricter conditions. So only if the member states justifies those conditions, then it may set additional conditions for service via email. If not, then the service via email will apply as regulated here in this article. And then I think here we are approaching the part which is not so interesting for you as practicing lawyers, because this part concerns more the member state, which has to organize somehow its application or implementation of this regulation. And this is here we see the article on the data collection. I think that nowadays not many member states collect data on how a regulation is applied or how many cases, for example, we had where we applied the service of documents, how many cross-border requests we sent, how many requests we received. So, but this information at the same time is very important for the Commission, because based on this information, then the evaluation of the application of the regulation is done at a later stage. And that's why the Service of Documents regulation now foresees that the member state will have to collect and send to the Commission the data which is available for the purposes of evaluation. What does it mean available? Well, if the member state collects the data, it will send it. If not, there is no way that it will be sent. This is again a compromise, as you can see. But all the requests which go through the electronic system are considered to be available, because there is this very simple feature of the electronic system which may just count, like a counter, how many requests were sent or how many requests were received. So the data which goes through the electronic system is always considered to be available. And of course, the regulation contains the list of data which has to be collected. It is in Article 34. I'm actually coming to an end. I just wanted here for your information, to draw your attention to these rules on the default judgment. There is no change there. The old Article 19 remains the same, but I wanted to draw attention to this Leibniz case, based on which the Commission had the intention to introduce some modifications, but they were not accepted by the legislators. So this Leibniz case is a very important case, and I just advise you to read it and to have it in mind when you if you find yourself in a situation where you have to deliver a judgment when the defendant did not appear. Then you will find in the regulation those very general rules concerning the respect of fundamental rights and the protection of personal data. Well, on the personal data, I have to say that the GDPR continues to apply. It is applied now, and the respect of the fundamental rights continues to be as obligatory as if we have not mentioned them in the regulation. But I just wanted to clarify for you not to wonder why those were included. This was actually a result of a compromise, and they were included just as a reminder that this is something that we should continue to adhere to. And then you will read in the regulation the term reference implementation software. This is again not something for us as lawyers, but put in a simple word, the reference implementation software constitutes the national IT system, which the member states should have in order to be able to exchange with other member states and in order to comply with their obligation under the regulation for this electronic communication tool. The reference implementation will be developed by the Commission and will be given for free to those member states who want to use it, and those member states who do not have their own national systems. Here is the time for my thank you and the question and answers. Before I go and before I wait for your questions, I just wanted to draw attention to this link which I put here. It was this Tuesday when the Commission published a public survey for its future initiative, which is named Digitalization of Cross-Border Judicial Cooperation. And basically this initiative aims at doing what have been done for the service of documents, but in all other instruments in the civil, commercial and criminal law, which foresee for judicial cross-border cooperation. So we just want this digitalization to be transferred in all other instruments for judicial cooperation. And I will very much invite you to have a look at the questions. There are not that many, just 15, but I think this gives you a unique opportunity to participate in a way in the decision, the shaping of the decisions which the Commission will have to make. So I think it's really a unique opportunity. Thank you so much, and I'm ready to reply to your questions.